So guys, very good afternoon. We have only Rishabh and Yashashvi in the class. So let us start the class now. So yesterday we were studying about the partnership, and fairly good thing we have studied, and I was just teaching your the counterpart, means the other class itself. So today we will be studying about the kinds of the partner, and I hope your class has submitted fairly good number of assignments to your CR Shaurya Dikshit. Yesterday he was telling me that he is having uh, about 40 assignments done from you guys yesterday itself. So how many of you, those who are in the class, how many of you have done the assignment from this
So
five
sorry.
of you? Raise your hand, those who have done the assignment yesterday's assignment yesterday itself. Come on. Very good, Rishabh, Yashasvi. So while in the class you have all done it while I was teaching you. Yes, Rishabh Goyal also.
No, sir. Yes.
Okay, Yashasvi, you did it did it in the class only.
So it's a little bit from the class and then little bit from like I was just figuring out. So
Excellent,
half
excellent.
of that was done in the class.
Very good, my
Yes.
dear. Great. So let us proceed further with the kinds of the partner, because you have yesterday you have studied about the distinction between the partnership, co-ownership, Hindu undivided family, and company. So you have on one chart you have prepared, and I hope your fundamentals regarding the difference between these would have been more clear by the time now. Okay, so let us now proceed further with this. So kinds of the partner, so actual or the active partner. So these are the ordinary types of the partners who actually invest into the business of the firm and actively participate in the functioning and management of the business, and also share the profits as well as the losses. So they are the normal partners. So they are no one else but the normal partners who are normally in the business. So if there have to be some special kind of partner, then they have to tell that we are having some special features of being a partner. For example, a person who will be partner only in profits, he has to be specific that I will not share the losses. But otherwise, normal partners, which are called partners, are the actual and active partners only. So such partner, as actively participate in the firm's business, they bind themselves or himself and other partners by all their acts in the usual course of partnership business. So such partner must give a public notice, okay, of his retirement from the firm in order to absolve or gets himself or set himself free from the liability of the acts of the other partners done after his retirement. Because he is the active partner and public knows him that he is the partner of the firm, and the public will deal with the firm accordingly, just considering that, oh, he is the partner, so fine, we should deal with the firm. Or even sometimes, oh, he is the partner, we should not deal with the firm. So both the things happens. Okay, so in that case it is required that if any active partner is retiring from the firm or is discontinuing his relationship with the firm, must also tell in public that, okay, from today and onwards I will not be the partner of the firm, so that the people should or should not deal with the firm, because it totally depends on that how they will be doing it. So it is fully on them that how they should deal with it and how they will be able to appreciate it, or how they will be able to take the decision of dealing with the firm with the presence or absence of any partner. So it is required that he must actually tell that he is a partner or not a partner. Next is a sleeping or a dormant partner. So the sleeping or the dormant partner actually invest money in the firm's business, and they take their share of profits but do not participate in the functioning and the management of the business, because they are sleeping. But that's why they are called sleeping or the dormant partners. They have invested in the firm, but they will not take part in the activities of the firm. But even then, because they are not taking part, even then, their liability is unlimited, means they are as liable as other partners are. Okay, so they will be liable for the losses also. They will contribute in the profits also, but they will be as liable as the other partners. So if they are not doing anything in the firm, or if they are not at all participating in the firm, but they will be equally liable as the other partners. So the acts specifically provides that if an act is binding on the firm, every partner is liable for it. Okay, so a sleeping partner can retire from the firm without giving any public notice because he is a sleeping partner, nobody knows him. So as he is a sleeping partner, he need not to give any public notice before severing off his liabilities or severing off his relation with the firm, because nobody knows him. It hardly matters. Okay, so his liability for the act of the firm ceases as soon as he retires, and such partner has no duties to perform, but is entitled to have the access of the books of accounts of the firm, and he can also have a copy of them like other partners. So all things are same for the partner, but the thing is that he actually doesn't works for the firm. He is a sleeping partner, and all remaining things, all the duties and all the you can say rights of the other partners, he will also be having enjoying all the rights. Next is a nominal partner. So some people do not invest in the firm or participate in the management of the firm, but they only give their name because their name is so big that the name itself will make the firm earn like anything. So their name is sufficient for the firm to earn. So they are called nominal partners because nominal means just for the sake of name, only naam matra. So they are just for the sake of name, giving their name, they have become the partners, and they may also tell that, okay, I will not be sharing losses. So in that case, they will be partners, nominal partners for profit only. So next is partner for profit only. So unlike the sleeping partner, they are known to the, because sleeping partner nobody knows, but nominal partner everyone knows. So they have to, they have to declare that because they are known to the public, so they must declare in a public notice when they are separating from the firm, because the public may be, because he is a nominal partner, public may be dealing with the firm because of the presence of this nominal partner as a partner of the firm. So public must know that the person is no more a partner. That's why they should think whether they want to go with the firm or not. So it's totally depends on them whether they want to go with it or not, but they have to actually, and these partners should actually declare when they are going to retire from the firm. Next is your partner in the profits only. Just now I told you about a partner who is entitled to share in the profits of the partnership firm without being liable to the share of and the losses is called partner in the profits only. Thus, a person who has sufficient capital but is not prepared to take risk may be admitted to the partnership firm by the other partners. So why they will be admitted? Because sometimes the partners of the firm may not be, they may be capital deficient. Okay, so they need capital, but they have skills. So this person will be included because he will be bringing huge capital along with him. So and the benefit of that capital the other partners will also enjoy. But this partner can keep a condition that I will not share the losses. I will be sharing only the profits if any arises. If the loss is there, then I will not share the loss. Loss will be borne by the remaining partners only. So this can be a condition on which this partner may be admitted. Okay, so in spite of the specific position, he continues to be liable to the third parties for all the acts of the firm, just like other partners. So each and every partner will be liable to the other parties, to the third parties for all the acts done by the partners on the firm itself. Okay, so it is one of the important clause. Next is a sub-partner. So where a partner agrees to share his profits in the firm with some third person. So that third person is called a sub-partner. So all sub-partner. This sub-partner is not a partner in the firm. Okay. So although this sub-partner is not a partner firm, he is partner of a partner only. So sub-partner is a partner of a partner, and the person whom he is having a partnership is a partner in the firm. Okay. So because he is a sub partner, he is having a partnership with the partner of the firm only. Okay, so such sub partner has no rights or duties towards the firm, and he does not carry any liability for the debts of the firm also. So he can neither participate in the partnership business nor check the accounts of such partner, because he is not a partner in the firm at all. Even he cannot claim his share in the profits also. He also, and he can, neither he is bound nor he binds any firm or any of the partner of the firm by his acts. The only right he has is the right to share profits in the property of the firm if he has contributed any through the partner, the actual partner. Okay. Next is partner by stoppel or holding out. This we have actually discussed when I was teaching you the Indian Contract Act. So a person who is an agent by stoppel is a person who has actually declared that he is an agent, and he is making the public believe that he is an agent, and accordingly he is acting, but he is actually not. Then he will be called agent by stoppel. In the same way, a particular person who is not a partner of the firm, but he is allowing anyone else to consider him as a partner, so he will be the person, and then afterwards he will be stopped to just declare that he is not a partner. Okay, so such type of person is a partner by stoppel or the partner by holding out. Okay, so he will be, and at the same time he will be liable for all the activities of the firm, and his activity the firm will also be liable, because the firm who has not declared him as a partner and allowed other persons to treat him as a partner. So what is the effect of holding out? So holding out partner becomes personally and individually liable for the acts of the firm, but he does not become a partner in the firm and is not entitled to any rights or the claims upon the firm. So an outsider who has given a credit to the firm thinking him to be a partner can hold him liable as if he is a partner of that firm. So as the liability of the partner is joint and several, he can be held liable to pay the entire amount, but under the doctrine of subrogation, then he will be able to, recover that amount from the other partners also. So doctrine of subrogation is equally applicable over here. Okay, but see here, what is the thing which we are getting? One person should not declare himself to be a partner, otherwise he will only be liable, and he will not be having any rights. So it is better not to declare yourself as a partner of any of the firms. So there are certain exceptions. In these three exceptions, he or the firm cannot bind, means both of them cannot bind each other. Number one, if he has done or firm has done or other partners have done any tortious activity, which is a criminal offense. Secondly, if he is going to die or someone else is dying, so his estate will not be, he will not be having any you can say any interest in that state or any right on that state. And further, even if he is becoming insolvent, then also there will be no effect on the firm, and any partner of the firm getting insolvent, he will not be affected by that. So these are the three exceptions. Next is minor to be admitted as a benefits of the partnership. So anyone, can you tell me about what is the position of minor in this case? Anyone from you? We have discussed it before. Can anyone tell me what is the position of minor? Come on. What is the position of minor in partnership? Anyone? Or should I ask you? Akash Jindal. What is the position of minor? Akash Jindal. You are there or not? Yes, Dipti. You will tell?
Yes, sir.
Yes, Dipti, tell.
Sir, a minor is like admitted to all the benefits of the partnership, and he has full rights of being a partner, and so he's not personally liable to the third party for the debts of the firm, but he has a limited liability.
Limited liability. What limited?
Like only up to the shares, up
Yes.
to his shares,
So,
the
to
liability
the
is
shares
limited.
which he has invested, he is liable up to that. Means he may not get the money which he has invested back. That is maximum what you can make him liable for, not more than that. Okay, what about his contribution in the losses? Come on. Yes, anyone else? Ashutosh Sharma. Abhishek Sisodia. Devyanshi. Devyanshi.
Sir, minor is not personally liable for the losses.
Dipti, wait, yeah. You have already told. Now let me ask others also what they are doing. Gaganjit Singh Khangarot. Khushi Wadhwa. I hope you are there in the class. Khushi Wadhwa.
Yes, sir.
What is the position of minor in the losses of the business? Khushi,
Yes, sir.
what is the position of the minor in case of losses of the firm? मेरे सामने लिखा हुआ है यार, यहाँ से देख के पढ़ लो. Come on. लगन. लगन, are you there? नमन. जयंत द्विवेदी. जयंत. जयंत द्विवेदी, are you there? हार्दिक रहेजा. हार्दिक. I will mark all of you absent, I am telling you. Take it seriously. Jaipal Singh Tamar. Only Dipti has taken the initiative. Parija Sharma.
Yes, sir.
Oh, Pranav, sorry. Pranav. What is the position of minor?
Sir, a minor has no liability to bear the losses.
Minor has?
Minor need not to bear the losses.
Minor need not to bear the losses. Then who will bear the loss?
Sir, the rest of the partners.
Why so?
Because he is not even getting the share of his profit.
No, he is getting the share of the profit. Minor is a person who is admitted to the benefits of the partnership only. Getting my point or not?
Yes.
Priyam Soni. Priyam Soni. What do you want to say regarding this? Sagar. Sagar Shirvi. Rishi Kanungo. Rishi. ऋषि कानून गो। भाई लॉ की क्लास चल रही है और ऋषि कानून को अगर नहीं बोलेगा तो फिर कौन बोलेगा? कानून की बात हो रही है यहाँ पे। आर यू देयर ऋषि? हाँ, ऋत्विक सेठी। ऋत्विक।
So,
या ऋत्विक। संज्ञा।
yes, so Sangya.
या संज्ञा, what you want to say?
Sir, a minor cannot be a partner in the firm because the contract does not allow so. And sir,
Okay. Very good.
he or she can inspect the books. They also have a share in.
But you are saying that he will not be the partner. Then why he or she will inspect the books? How can minor be there? Can minor never be there as a partner? Or can minor be there as a partner, but only in profits?
Yes, sir. Minor can be a partner, but only in profits.
Only in case of profits.
Yes, sir.
So why not in losses?
Because he or she does not have the capacity to pay
Very
back.
good. Very good. And one more thing, minor can be admitted to the benefits of the partnership, but only by consent of all the partners. Isn't it written over here? Huh?
So why would they admit a partner if why would they admit a minor if he or she cannot share the losses? I mean, what's
Yeah,
the
what
point of
happens?
partner?
Yeah, your question is very valid, and very much. And I'm glad that you have asked this. See what happens if a partner who is already there in the business, if he dies, and his minor son wants to join the partnership. So all the partners can decide that he can become the partner of the firm because his father has served the firm for such a long time. Okay, so that can be a case. Or sometimes what happens, a minor is especially capable. Especially capable means, for example, a minor is a person who is a very good singer, and this firm is making music. Okay, so he may be admitted for the in the partner because they also want him to be admitted as a partner. Okay, because he may be at very small age, he may have gained that special skills to sing and to do the things, and he has gained that his national importance also. He has been awarded recently by president
So
or something like that.
the goodwill of the person.
Absolutely. So in that case, because he's a minor, and the contract doesn't allows minor to be admitted as a partner. Okay, so he but initial but one thing Sangya is very clear that a partner though may be admitted. Admitted means he can be there in an existing firm. If the firm is existing and all partners agree together, then he may be admitted as a partner. Now, just see what it is written. Minor admitted to the benefits of the partner. So admitted word is there. So it is very clear that if you want to start a you can say uh, uh, a new partnership, in that case, you cannot start it with the minor. That is for sure. He may be afterwards be admitted, but the partnership cannot be started with the minor. Okay. Sangya, okay?
Yes, sir.
Understood this? I think the point is very, very clear now.
Yes, sir.
Okay. So let us proceed further. So I hope the things which are written over here are very, very clear to you on this page. Let's proceed. So what are the rights of a minor? So he is entitled to his agreed share and inspect the books of accounts of the firm. He can bring a suit for the accounts and his share when he intends to sever his connections. So when he wants to cut off his connection from the firm, he can bring a suit for the accounts. Okay, so further, but not otherwise. So in a going concern, he cannot just tell, okay, please show me all the accounts now and tell me what is my share in it. He cannot do so while the firm is a going concern. But when he wants to sever off his connection with the firm, then he can do so. So a minor who was admitted to the benefit during his minority within 6 months of his attaining the age of majority, or when he comes to know his being so admitted, whichever is later, he has to elect whether he wants to become a partner or cut off his connection from the firm. So within 6 months he has to give. So he may give a public notice for his election to continue or repudiate. But if he fails to do so, then he will be considered as if he is continuing as a partner. Okay, so any negligence on the part of the minor will not bind other partners, right? So the other way around can also be there, that if he doesn't give any public notice, then he will be considered as a minor only, or his relation is severed off. It is not like that. But if he has not declared anything, he will be treated as if he wants to continue with the partnership itself. Okay. Next is relation of partner to one another. So the relation of partner arises through an agreement between the parties, and such agreement normally provides for the mutual rights and obligation and the duties of the partners, where however the partnership arises by the implication, or wherever the articles of the partnership are silent, or where they do not exist, the right and duties of the partners are governed by the acts. Otherwise, rights and duties are completely given in the partnership deed. That is the agreement between the partners. So interrelationship between the partners, who will do what, their rights, their duties, all things are there in the partnership deed itself. But if there is no partnership deed or there is no such agreement, then whatever is given in the act will be applicable to all the partners. Next is regarding the rights of the partners. So every partner has a right to take part in conduct and management of the business, right? So every partner, whether active or dormant, has a right to to freely access all the records, books, accounts of the business, so as to examine and they can also keep a copy of all those books and accounts. Further, every partner is entitled to share the profits equally unless the proportion is divided. So if the proportion is given in the partnership deed, in that proportion it will be given. If the partnership deed is silent about it, so everyone will be an equal partner irrespective of the capitals contributed by them. Okay, so this partnership ratio, or you can say the profit sharing ratio, has to be clearly specified in the partnership deed. Otherwise, even if a person has invested 10 rupees and another person has invested 1 lakh rupees, the proportion of the partner of the profit will be equal. So partnership deed doesn't partnership act doesn't say that the the proportion of the profit in the partnership is on the proportion of the capital invested. No, it says that it will be equally divided, okay, irrespective of the contribution. Further, a partner who has contributed more than the share of his capital for the purpose of the business, then he is entitled to interest at the rate of 6% if the deed is silent, and if there is a deed and some interest is written over there, so whatever interest is agreed upon, he will be paid that. But if you forget to just put this clause in the deed, then 6% is the applicable rate. But partner cannot claim interest on capital unless there is an agreement to pay it. So this is an extra money over and above the other partners that is entitled to 6%, but not the thing which is normally in the as a capital. So all the partners who have given their capitals, they cannot charge interest until unless it is agreed upon. Okay, if it is agreed, it's given in the deed that interest of rate of rate of capital will be given on that. Otherwise, there is no such provision. And but in case of the excess capital invested, 6% rate of interest will be there. Next is the partner is entitled to be indemnified by the firm for all the expenses incurred by the firm in course of business or all the payment made by him in respect of the partnership debts, liabilities and disbursement made in emergency for protecting the firm from the loss. Okay, so partner who is working on the behalf of the firm is entitled for all making good all the losses, all the payments which he has done on the behalf of the firm. He is allowed to take that particular fund from the kitty of the fund of the firm which he has which but only for the purpose of business only. Okay, and every partner is as a rule is a joint owner of the partnership property and have applied exclusively for the purpose for which of the partnership itself. So they all have. Now this is something which is different from the company. In company's case, what happens in case of companies, the members do not have the joint ownership of the property of the company, but in case of partnership, they all are called the joint owners of the property of the partnership. Further, a partner has a power to act in emergency for protecting the firm from the losses. So whatsoever he thinks fit or he thinks good to protect the firm from the losses in case of emergency, he is allowed to do all those things. Okay, every partner is entitled to prevent the introduction of new partner into the firm without this consent. So a new partner cannot be admitted until and unless consent of all the partners are there. So any change, any alteration in the firm can happen only by the consent of all the partners. Okay, so if somebody else is to be admitted, then all partners should consent it for, and then only the person will be admitted. Further, every partner has a right to retire by giving notice. Where if the partnership is at will, every partner has right to contribute in the partnership and not to be expelled from it. So expulsion of partner, there are some strong reasons, because either it is against the public policy or moral turpitude. Until unless it is there, they may not be expelled. Okay, so anyone, even the majority of the partners cannot expel one partner from the firm. What will happen, that partner which is to be expelled, he will just announce for the dissolution of the firm and the firm existence will be a big question mark. So an incoming partner will not be liable for any debts of the firm before the partner. Every outgoing partner in the same way has a right to carry on the competitive business under certain conditions. So whatever is the agreement between the outgoing partner and the firm, according to that conditions, the other partner who is leaving the firm is having the right to start any competitive business also. Further, there are certain duties of the partner. So any question regarding rights of the partner? Anyone? Anyone? Tanish Agrawal, are you there? Surbi? Surbi Singhal?
Yes, sir.
Any doubt, beta?
No, sir.
Good, good. समझ में आ रहा है ना सब?
हाँ जी.
Excellent. Duties of the partner. Now, as we have just studied about the rights of the partners, so every right corresponds a duty of the person towards whom we have the right on. So if we are having rights on our parents, there are some certain duties which we must do for them, or we must have it for them. Okay. So in the same way for partners and partnership also, if certain rights are conferred to the partners, they have to undertake certain duties also. So every partner is bound to carry on the business of the firm to the greatest common advantage. So it is a duty of the partner to just do the business for the greatest common advantage of the firm. So every partner must be just and faithful to the other partners. So there is a relationship of trust between the partners, because the agency is a contract of trust between the partner. There is a fiduciary relationship between the partners and the other partners. Okay, so a partner and the other partner. So everyone is an agent and everyone is a principal. So every partner must be having a just and faithful relationship with other partners, and they must create that and they must maintain the trust amongst themselves in order to flourish the firm. So a partner is bound to keep and render true, proper and correct accounts. Again, the matter of trust. Okay, so utmost good faith between the partner is the rule, and one partner must not take advantage of the other. So as an agent of other partner, every partner is bound to communicate the full information about the things, and they must work in good faith. So every partner must account for any benefits derived from the partnership business without consent of the other partner. So any partner is must not make any secret profits, and if any secret profit is being made in the due course of time, he must disclose that secret profit in front of all the partners of the firm. Next, a partner must not compete with the firm without the consent of the other partners. Any profits made by such unauthorized competition may be claimed by the firm if he does so. So with the consent of all the partners, he can compete, but normally partners do not give permission to the existing partner to compete with the firm. Okay, it will be just like defrauding the other partners. Next, every partner is bound to attend diligently to the business of the firm, and in absence of any agreement to the contrary, he is not entitled to receive any remuneration, because all partners have joined hands together in order to run the business. So every partner must run the business. They should contribute in the business. Okay, and they should not ask for the remuneration until unless it is agreed well in advance. For example, a person who is a chartered accountant and is also running a business of suppose textile, so he himself can prepare the accounts. Who will prepare the accounts better than an internal person? But as he is preparing the accounts, so the firm is saving the money which otherwise would have been paid to the CA. So he may ask for half of the amount or something like that, so that firm can allow. Okay, so until unless it is agreed, there should not be any extra remuneration for the partner. So in the absence of the agreement to the contrary, every partner is bound to share the losses equally. So because profits are also rights, the losses are the duties, so have to be shared equally. So every partner must hold and use the partnership property exclusively for the firm, not for any personal purpose. For example, there is a car in the firm, the car should be used exclusively for the purpose of the firm, not for just taking the family to the trip. Okay, so every partner is bound to indemnify or make good the loss of the firm which has been caused because of the fraud which has been conducted because of him. So anyone who is involved in certain things because of which the firm is bearing the losses, then such partner should indemnify or disburse or reimburse that particular loss he has made because of his own mistake. Further, a partner who is guilty of willful neglect in conduct of a business and the firm suffers losses in consequence is bound to make the compensation of the firm and the other partners. No partner can assign or transfer his partnership interest to any other partner so as to make him the partner in the firm. So transferability of interest is also not at all allowed. Even if he transfers, it may not be accepted by the firm. But a partner may assign the profits and the share in the partnership assets, but the assignee or the transferee will have no rights to ask for the account. So this is something related to the sub partner. If there is any sub partner, he may assign certain profits share in the firm to him, but that assignee or that particular sub partner or a transferee will be having no right to ask for the accounts or interfere in the management of the business. He would be entitled only to share the actual profits, and that too the share of his partner only. On dissolution of the firm, he will be entitled to a share of in the asset if he has contributed any through that partner, also to the accounts, but only from the date of dissolution and not before that. Further, every partner is bound to act within the scope of his actual authority. If he exceeds his authority and there are losses, he shall compensate other partners for any loss which has been incurred. Further is the relation of the partners with the third parties. This we will be continuing tomorrow, right? Partners as an agent, authority of the partner, implied authority, extent of the liability of the partner. So these all death and insolvency, then dissolution, and the provisions regarding the dissolutions are also here. So we can just study this. So only two more classes are required. One is for this particular what you call is the relationship between the other parties, and another class for dissolution, and your partnership will also be over by the time. Okay, so this is what we have studied till now, and let me just show you where we stand. So here we are at present. This is, I think, 34th class today. So here we are. Rights and obligations or the duties of the partners we have already studied, but there are certain portions which are remaining still now. Registration of the firm process, partnership deed we have done, relationship of the partners we have to do tomorrow, kinds of partners we have already done. So two more classes, one for dissolution and another is for the other things. More will be required in order to finish it off. Okay, then only one more act will be remaining, that is your limited liability partnership, and that is also not too long. 3-4 more classes will be required in order to finish it off, and then we will go for revision. Is that okay? Is that okay?
Yes, sir.
Fine.
Yes, sir.
Okay, then let me take the attendance. Yes. Akash Jain, please say yes, sir. Akash Jain, Abhishek Singh Sisodia, Adhiraj, you were not there before. You have just now come.
Yes, sir. No,
So
sir,
why
I have
so?
joined, but my class was disconnected, so I have joined
Sorry?
again. Sir, my class got disconnected, so I have joined again.
Class got disconnected.
Yes, sir.
Actually, you never connected in the class.
Yes, sir, I was connected, sir. You can check.
Okay. Akash Jindal,
Yes, sir.
Ashutosh Sharma,
Yes,
Dipendra
sir.
Gujar, धीरज लांबा इतनी लेट क्यों आ रहे हो भाई? धीरज लांबा, अभी भी नहीं है. दीप्ति राकेश, दिव्यांशी, फजल अहमद,
Yes, sir.
गगनजीत, कनक शर्मा, गौतम गोधरा, हार्दिक रहेजा, जयपाल सिंह, जयंत द्विवेदी,
Yes, sir. Present.
कशिश शर्मा, खुशी वादल,
Present, sir.
लगन महिपाल, लकी चौधरी, मेहर अग्रवाल, नवान सिंह, परिजा गुप्ता, शर्मा, प्रियम सोनी, ऋषभ गोयल, ऋषि कानूनगो, ऋत्विक सेठी,
Present, sir.
सागर शिरवी,
Yes,
साहिल
sir.
खंडेलवाल, संज्ञा गुप्ता, श्रेयांश जैन,
Yes, sir.
Present, sir.
सुरभि, तनिष अग्रवाल, तरुण सिंह,
Present, sir.
वैष्णवी मिश्रा,
Tanish
विक्रमादित्य सिंह, विशाल चौधरी, यशस्वी पुरोहित.
Present, sir.
Dheeraj present.
Sir, Ragar Singhal present, sir.
हाँ ठीक.
Sir, Dheeraj present. Subhan Mandania present, sir.
Sorry?
Present also. Sir, Ragar Singhal present, sir.
हाँ ठीक है. Okay, fine then, guys.